Hi, I'm Ellie. I'm one of the law teachers at QE, and what I'm going to do in this video is I'm going to talk you through the law and self-defence in relation to a case that we've already had a look at, and we're going to have a little bit of a discussion about why the judge reached the decision that he did. So grab your notes and let's get started.
Okay, so let's have a look at our case of Hussein and Hussein, and let's figure out whether or not self-defence will actually work. So hopefully you have gone through the worksheet and you might already have an idea yourself about whether it will work. And this is actually quite an easy case in terms of the law. So let's have a look at it. First of all, we need to establish, is the force necessary? So the first thing we need to think of is, did our two defendants believe that they needed to use force? Originally, yes, they probably did believe that they needed to use force. Remember, our victim, our intruder, was escaping, and so they had to use force to stop him. We then need to figure out, was the threat imminent? So was the threat about to happen then and there? And quite simply, it was to begin with, but not when the force was then used. Remember, our victim was running away. He was escaping the scene, and they used force after he was on the floor. So let's have a look, was the threat over? Again, quite simply, yes, the threat was over. So it's likely here that the force is not necessary. But let's have a look at whether or not the force was reasonable. So is it proportionate to hit someone who is running away with so much force that their cricket bat breaks into 3 parts? Again, quite an easy answer. In some situations, maybe. So if they hit him as he was running away, then yes, potentially it's reasonable. However, our defendants hit our victim when he was already on the floor, and therefore the force isn't reasonable. So what we've established here is the force was not necessary at the time, nor was it reasonable. It's a little bit of a complicated case in the sense that our judge acknowledged the horror that our defendants had been through. He accepted that they'd been subjected to this terrible and terrifying ordeal. However, what our judge said was that he had a duty to impose a prison sentence. Quite simply, people cannot take the law into their own hands, otherwise our system of criminal justice would just collapse. And what originally happened was Mania, defendant number 1, he received a 30-month prison sentence. Tokia, defendant number 2, received a 39-month prison sentence. So the reason that there is a difference there is quite simply Tokia was not subjected to the same degree of provocation as what Mania was, because he wasn't there at the time of the original burglary. This was then appealed, and what happened on appeal is those sentences were reduced down to reflect the ordeal that they had gone through. So Mania then received a 12-month suspended sentence. So what that means is that he doesn't have to go to jail, and if he doesn't commit any more offences for 12 months, then that's it, he doesn't go to jail. However, in those 12 months, if he does commit an offence, he will be sentenced for the first one, so this one, plus the second offence. Tokia then had his sentence reduced down to 24 months prison, and again, that's just because he wasn't subjected to the same degree of provocation. So on our course, we will learn self-defence in quite a bit more detail. We'll have a look at a few more different cases and how they link to the law. And we'll also learn quite a few other defences and those offences such as assault, battery, and Section 18 grievous bodily harm that our two defendants were charged with. So what we'd like you to do is have a go at our other Bridging Week activities, have a look at the different topics and the different cases that we'll study throughout the course. If you do have any questions about anything, then please do email us. We will be checking this over the summer. And please follow us on Twitter for new and exciting insights into the law, different resources that you can be having a look at. And we really look forward to seeing you in September.